My name's Jacqueline Smart. I'm actually a lawyer, not a historian primarily, but I've discovered academia and I've discovered legal research. There's a colleague in the room behind me is actually laughing at that because it amuses my colleagues. Anyway, I'm primarily trying to research a biography of a particular coroner. As a result of that, I'm looking at his inquest, and they tend to raise interesting cases, which I then try and follow up to the assizes or any other background to it. Now, my resources, because of the age that I'm looking at, there's not an awful lot in the archives that I've found yet, and there's only the odd thing. So I'm using the local newspapers and family research sites to follow up where people came from or what happened to them. But the newspaper reports, particularly the northeastern ones, are they were very good at reporting, and they reported where the cases interested them. They would have not just a summary of an inquest, but they'd be reporting all the evidence, and the same for the assizes. So there is a lot of material there. Um, so, what's the crime in this case? Well, Louis Henry, and it's Goule. I apologise, I couldn't work out how to put the accent on the surname, but he was of French extraction. And his wife Emma had developed a rather troubled marriage, and in particular, for the few weeks before the crime, Louis had developed suspicions about the fidelity of his wife, and in particular, had suspicions of Walter Scruton. Um, on the evening in question, there was another occasion of words. Uh, Emma was threatening to leave, and she saw Mr. Scruton coming down the street. So she said she was going to call him in, the implication being to try to tell Louis there was nothing in it. He said, "Don't do it." She went to leave the house to do it, and he pulled a loaded pistol out, shot her. It was not the most serious of injury because she put her arm up to block her face, but and ran across the street away from him. And then he pulled out a second loaded pistol and shot at her again, which one missed. It's actually a very tragic case because unfortunately she eventually died of tetanus. Not content with shooting at his wife, he ran across the street at Mr. Scruton. Uh, the evidence of the witnesses said it was like a wild man, seriously assaulted him, jumping on his back, clubbing him with the butt end of the revolvers, and the neighbours had to drag him off. And he was taken to the local police station and then held in custody, where he tried unsuccessfully to cut his own throat with a penknife. So papers are actually reporting all the detail of this. It has become so interesting because Louis Henry Goule was a superintendent of the Durham Division of the Rural Police, and Walter Scruton was a local solicitor and a deputy clerk of the peace. So you can imagine the newspaper reports, which were originally absolutely delighted in reporting all the excitement in Durham about this case. And at the first stage, it was somebody who'd injured his wife, so there was a magistrates convened to carry out an inquiry. And then the disaster happened, and Emma Goule died from tetanus. So immediately the situation converted into the need for an inquest. The inquest took place on the 17th to 18th of June, and there very interesting matters started to arise. Comments in the papers point out that Mr. Scruton was not in court, and we're rather surprised he wasn't called as a witness. And his name is very little mixed up in the evidence adduced. There was another inhabitant of the household, and that was a relative, Mary Jane Giles. And she appears to have been a confidant of Emma Goule, and she gave a lot of evidence about what had been happening. In particular, that Emma had told her that she thought that Louis was not right in the head, there was something wrong. He'd been very much worse the last fortnight and had frequently been saying, "Oh, my head, Emma, talk to me, my head." Now, background matters. Why was a policeman armed with 2 pistols? There's a lot of an issue about whether this was premeditation or whether it was spur of the moment reaction to his suspicion. Louis, when he'd been taken into custody, gave a pocketbook to Thomas Sewell, who was one of the 2 neighbours who detained him, and indicated to him that there was something in it that was to explain everything. The suspicion was that there was some sort of letter, but from whom, whether it was something Louis had written or whether it was something he'd intercepted a letter. It was never ascertained. And eventually, Thomas Sewell denied that Louis had ever said anything to about him. But the pocketbook was handed over to the clerk to the magistrates. The coroner inspected it, so this was a matter of days later, and said there wasn't anything in it that bore the slightest degree on what happened. And there's a curious thing keeps cropping up about Emma Goule having told Jane Giles she'd received blue violets, but again, not from whom. So there's all sorts of suspicion and undercurrents running behind this case. Obviously, there was a crime committed. At this time, if a coroner and the coroner's jury investigated, then they could have a verdict of what crime had been committed and commit to the assizes. And they had taken over from the magistrate's investigation because Emma had died. The coroner, who was J.M. Favell, who's the gentleman I'm actually primarily researching, he gave a coroner's direction. There was somebody in court watching for the prosecution, and he actually deferred to him to make sure he got the direction right. And the person in court for the prosecution said he had. And then the matter goes to the coroner's jury. Now, after only 10 minutes, they decided it was a case of manslaughter. That's the narrative verdict there, that Emma Goule came to her death by a pistol shot fired by Louis Henry Goulet, was in a state of great mental incitement. So the matter has to go to the assizes, and it's committed to the assizes on the basis of manslaughter. Then we're going to get into a position where the huge spanner put in the works in relation to the assizes. Now, by the time it gets to the assizes, there's obviously concern about Louis's mental state, what it actually was and what caused it. And the year before, he'd been actually injured in the course of duty. Again, I haven't time to go through it all, but there's lovely descriptions in the papers because he was trying to arrest 2 gentlemen with some other policemen. The policemen who were the ones who were supposed to be doing the work didn't succeed. So Louis took the cutlass from one of the men, little picture there of what the policeman carried, and he was trying to get the men down from a loft. They were striking him with a joiner's adze and an iron drill. He was trying to parry the blows with a cutlass, and he injured one of them several times. Greenwell, who he injured, then got hold of an iron rammer. It's what you ram the explosives in a mine with, so it's it's a pretty effective weapon. And actually hit Goule in the head with it, and did actually cause him a serious injury. He started off trying to accompany the men when they captured them to the omnibus that was going to take him to Durham jail, but he collapsed. A local surgeon was called, and he ended up being confined to bed for a week, and then at home under medical supervision until the 10th of July in 1844, and that's the year before this happened. And so concern started to develop as to why he was exhibiting and seeming to react excessively and ending up killing one person and really badly injuring another. Now we come to the spanner in the works. The presiding trial judge at the assizes to which Louis was committed was Baron Rolfe. And at the assizes, the presiding judge, that we did have a grand jury at that time, and they had to go through all the cases that were committed, look at the depositions, and decide whether or not what we sort of colloquially call a true bill, whether it should go on to the jury, and they could occasionally throw bills out if they didn't think there was sufficient evidence to support it. At the beginning of the assizes, on the first day, the presiding judge would go through the cases that were in the list, generally just making general comments, which could conclude anything but bewailing the lack of education on the people who were turning up as accused, or criticising that there were not enough grand jurors. But the judge would also have a look at the cases and see if they needed to address the grand jury in particular on any of them. And his direction in his address to the grand jury was that he saw that Louis had been committed for manslaughter, but it will be my duty to direct you to charge him with the charge of murder, because according to the depositions, there is nothing in the case to warrant the extension of the law which could mitigate his offence to a charge of manslaughter. There was nothing at all but a man having conceived truly some feeling of jealousy as to the conduct of his wife, a certain person passing by in the street at the time when they had some words about it, his wife determining to go out and call the party in, and then the prisoner drawing from his pocket a loaded pistol and shooting her, and not having succeeded, he thought with that he fired at her again. And so he directs the grand jury to charge the petty jury with a charge of manslaughter. Now, if you think about it, by this stage, the barristers are briefed for prosecution and defence. They would have been briefed on the basis of manslaughter, and all of a sudden, the presiding judge says it's not. It's murder, and of course, at the time, it's a capital case, and you've got to feel a bit of sympathy, at the very least, for the defence and prosecution. Now, locally, it is quite clear that the establishment and all the legal establishment at this point think, because of the mental condition of Louis, that it is a manslaughter case, it's not a murder case. Despite what the judges directed the grand jury, this is the prosecutor. Okay, he's not going to say what the distinction is between one offence or another. He's going to leave it to the judge. But he begs the serious attention of the jury, and if it should turn out in the course of the investigation that were grounds for the reduction of the charge from that of murder to a lesser offence, how grievous the offence may be, there was no man who would rejoice more at the reduction than himself. That's the prosecutor saying to the jury, please find a way that this is manslaughter and murder. The problem that they had, and this shows why the system, the law was failing. The law of manslaughter now is wider, but at the time it didn't. You had to have a defence of insanity if mental health was involved in an offence of homicide. And there were the McNaughton rules, and just to summarise very briefly, you had to have someone who, by reason of a disorder of the mind, didn't know what he was doing, or if he did know what he was doing, he did not know that what he was doing was wrong. And the House of Lords, the judges who provided the House of Lords with the definition, actually went on to say that a party accused who did an act which was criminal under the influence of an insane delusion with a view of redressing or avenging some supposed grievance or injury, etc., is nevertheless punishable if he knew at the time he was acting contrary to law. And the difficulty in this case, it does appear to me, is that on the evidence that is recorded at the assizes, you cannot see that Louis didn't know at the time what he was doing, even if it was an insane impulse or delusion, that he was acting contrary to law. He's a policeman, and he would have known he was acting contrary to the law. So the poor defence barrister has to start extracting evidence, such evidence as he can of insanity. And he does that by cross-examining, and he's allowed to do it, to be fair, by the presiding judge. The surgeons who's involved and were treating Emma Goule. And there were two in particular. There was Mr. Green, who's on the next page, and Mr. Stoker. Mr. Stoker was Mr. Green's assistant. They were actually the family doctors. So Mr. Stoker does give evidence of that there seems to be a problem because of the injury, and also on the morning of this homicide, that there was something wrong with Goule. He seemed to be ill. He was given, I love the 19th century, he was given some port wine to pick him up. And after that, he became much excited, and Mr. Stoker had seen him excited before, since he got the wound the previous year. Mr. Green, who actually treated him after the injury, says how serious it was, that he feared the danger to him, that he'd seen him in his temper, his excitability after the wound, and it wasn't the same as it was before. But he says that Mrs. Emma had told him that he was a very violent temper, but he had been more so since the accident. And at the end of his evidence, he's just put the boot in and say that Goule was always of a very irritable temper. They frequently had quarrels before. And then the sort of schizophrenia you can get with persons who commit crime. He was also seen as a most civil and obliging man. So the poor defence barrister, trying to get out the evidence, gets the sort of conflict between this. There's still these undercurrents of the pocketbook blue violets and the absence of Mr. Scrutton. Note, he doesn't give away. He's never called by anybody to give any evidence of any stage of this. They obviously feared what he was going to see. And there was evidence from an officer of the rural police, saying how all the officers loved Louis Goule, and they'd actually raised the subscription for his defence. The defence barrister does everything he can in relation to this case. He does try, it might have been an accident, which is probably pushing his luck a bit. He points out the great mental anxiety. There was a suggestion that he and an excise man were going to be staking out and trying to catch some smugglers. And then a little bit of a sort of general swipe. Where's Mr. Scruton? Take note of his wife's familiarity with Mr. Scruton. He pointed out the inquest had returned a verdict of manslaughter. He didn't point out that the judge said that didn't run, and he asked the jury to carry out their duty with charity and mercy. That's a few buzz points from a very long speech that, not surprisingly, went over about 3 or 4 columns. He even called number of character witnesses, and then we get the summing up when the judge directs them again that it's only open for murder and insanity, and the way the judge directed, he was effectively saying it wasn't insanity. But the jury ignored all that, and their verdict was not guilty by reason of insanity. I've got one more. I'll leave the public and the press outrage. If I go to the actual, and usually in this case, by looking up Find My Past, it turned out that had on the Home Secretary's file, where there were immediately a number of petitions to actually get Goule discharged from Durham Jail, because he was sane. There is no every expert who's spoke to him found he was sane. So the Home Secretary asked Baron Rolfe what his opinion was, being the judge at the trial. And his comment was that the prisoner was a very respectable man and he had conceived, probably not altogether without foundation, poor Emma Goule, very violent jealousy of his wife. The supposition on his behalf was that just before the time when he shot his wife, he discovered that Mr. Scruton had made an assignation of a criminal nature, and that being then accidentally, and the evidence proved it to have been accidentally, armed with 2 loaded pistols, and having actually seen Mr. Scruton coming, as he thought, to meet his wife, he in a frenzy of despair discharged the pistols at her, which wounded her and eventually killed her. And then the killer, I do not think the man exhibited any modes of insanity at the trial. So that's an example of a legal process and the law that really could not cope effectively with the situation.